Ready? Exercise number 2, Series B, Legal Matter, start. There are two questions which arise for consideration in these writ petitions, and they have been succinctly set out in the judgment of Ranganath Mishra J. The first question is whether the exclusion of the jurisdiction of the High Court under Articles 226 and 227 of the Constitution in service matters is specified in Section 218 of the Administrative Tribunals Act 1985 under bracket hereinafter referred to as the Impugned Act bracket out, and the vesting of exclusive jurisdiction in such service matters in the administrative tribunal to be constituted under the Impugned Act, subject to an exception in favor of the jurisdiction of this court under Article 32 and 136, is unconstitutional and void, and in any event, even if the first question be answered against the petitioners and in favor of the government, the second question required to be considered is whether the composition of the administrative tribunal and the mode of appointment of chairman, vice chairman, and members have the effect of introducing a constitutional infirmity invalidating the provisions of the Impugned Act. Agreed with the answers given to these questions in the judgment of Ranganath Mishra J., I would articulate my reasons as follows. Quote, next para. It is now well settled as a result of the decision of this court in Minerva Mills Limited and others versus Union of India and others 1981 1 SCR 206 that judicial review is a basic and essential feature of the Constitution, and no law passed by Parliament in exercise of its constituent power can abrogate it or take it away. If the power of judicial review is abrogated or taken away, the Constitution will cease to be what it is. It is a fundamental principle of our constitutional scheme that every organ of the state, every authority under the Constitution derives its power from the Constitution and has to act within the limits of such power. Stop, next para. It is a limited government which we have under the Constitution, and both the executive and the legislature have to act within the limits of the power conferred upon them under the Constitution. Now, a question may arise as to what are the powers of the executive and whether the executive has acted within the scope of its power. Such a question obviously cannot be left to the executive to decide, and for two very good reasons. First, the decision of the question would depend upon the interpretation of the Constitution and the laws, and this would preeminently be a matter fit to be decided by the judiciary, because it is the judiciary which alone would be possessed of expertise in this field, and secondly, the constitutional and legal protection afforded to the citizen would become illusory if it were left to the executive to determine the legality of its own action. Stop, next para. It is undoubtedly true that my judgment is Minerva Mills Limited case under bracket supra bracket out was a minority judgment, but so far as this aspect is concerned, The majority judges also took the same view and held that judicial review is a basic and essential feature of the Constitution and it cannot be abrogated without affecting the basic structure of the Constitution. And it is equally clear from the same decision that though judicial review cannot be altogether abrogated by Parliament by amending the Constitution in exercise of its constitution power. Stop. Thank you very much.